Treaties in international law. The overview, the introductions to treaties, nature of treaties, treaty formations, reservations, treaty interpretations, invalidity of treaties, termination of treaties, state responsibility, and conclusion. Treaties are legally binding agreements between states that commit the parties to a particular course of action. They are a fundamental source of international law, shaping the legal landscape of the international community. While there are some similarities between treaty law and contract law, such as the role of consent, there are also fundamental differences. Unlike individuals, states can create international law when they enter into treaties with each other. This is because states are sovereign entities, and their governments and their agreements are considered binding under international law. The multilateral nature of many treaties also distinguishes them from contracts. Contracts are typically bilateral agreements between two parties, while treaties can involve multiple states. This multilateral nature weakens the analogy with contract law, as the interests and obligations of each state party must be considered in the context of the treaty. Treaties are the primary method of creating international law today. Understanding the legal rules governing their formations, operations, and terminations is crucial. Treaties can be compared to contracts in national law, with consent playing a significant role in both. However, there are important differences that will be discussed. Treaties are legally binding agreement between states in which they commit the parties to a particular course of actions. This is a fundamental source of international law. It shapes the landscape of international community. While there are some similarities, such as consent, however, there are certain differences as well. Unlike individuals, states can create international law when they enter into treaties with each other because states are sovereign. Treaties are therefore a binding agreement between states, and it creates rights and obligations. They're similar to contracts, but it differ in the states because states can create international law through treaties, whereas individuals cannot create national law through contracts. According to Article 2, Clause 2 of the Vienna Conventions on the Law of Treaties, VCLT 1969, it defines treaty as an international agreement concluded between states in written form and governed by international law. The term treaty is a broad term used to describe a wide range of international agreements. These agreements can be contained in a single document or a series of documents, such as an exchange of letters or the signed minutes of meeting between state representatives. For example, the Vienna Conventions on the Law of Treaties, VCLT, which governs the formations, interpretations, and termination of treaties, is a single document. However, the Treaty of Versailles, which ended the World War I, was a series of documents. Treaties can be referred to by various names such as conventions, covenants, declarations, statutes, acts, or protocols. They do not need to be contained in a single document and can be formed through a series of documents. For a treaty to be valid, the governmental officials negotiating and concluding it must have the authority to do so. This authority can be established through a full powers document, which is a formal document that grants an individual the authority to represent a state in international negotiations. Alternatively, the authority can be established by the involvement of the head of state, head of government, or the foreign minister. For example, the US president has the authority to negotiate and conclude treaties on behalf of the United States. Government officials must have the authority to negotiate and conclude treaties. This authority can be established through full powers documents or by the positions of the official, for example, head of state, head of government, or foreign minister. Authority to create treaties, it is given to government officials. because they must demonstrate the authority to negotiate and conclude the treaties. By producing a document showing full powers to represent the state, as provided under Article 7.1 of VCLT, heads of states, head of governments, and foreign ministers do not require full powers, as provided under Article 7, Clause 2 of VCLT. This was affirmed in the case of Cameroon vs. Nigeria in 2002, where the International Court of Justice ruled that a head of state has the authority to conclude treaties on behalf of their state, and resulting obligations cannot be avoided by referencing national law. States express their consent to be bound by treaty through signature and ratification. Signature indicates a state's willingness to consider the treaty, but it does not necessarily mean that the state is bound by it. Ratifications, on the other hand, it signals a state's willingness to be bound by the treaty. However, the legal commitments only arise when the treaty enters into force. This is typically specified in the treaty itself or agreed upon by the negotiating states. For example, the VCLT entered into force in 1980 after a sufficient number of states had ratified it. The key instruments, Article 11 VCLT, with regards to the consent to be bound, states express their consent to be bound by a treaty through signature and ratifications. Ratification is a common in multilateral treaties, while signature is more common in bilateral treaties. A treaty enters into force as specified in the treaty itself or as agreed by the negotiating states. The key instruments, Article 24, Clause 1 of VCLT, a treaty enters into force in such manner and upon such date as it may provide or as the negotiating states may agree. Under Article 11 of VCLT, it outlines ways states express consent to be bound by a treaty, primarily through signature and ratifications. Multilateral treaties typically require ratifications, while signature is more common in bilateral treaties. Article 24, Clause 1, VCLT states that a treaty enters into force in such manner and upon such date as it may provide by the states. For example, the Rome Statute of the International Criminal Court 1998, it was entered into force on 1st July 2002 after the 60th ratifications. Reservations allow states to modify their treaty commitments in relations to other parties. This can encourage their participation in multilateral treaties as it allows states to tailor their obligations to their specific circumstances. The VCLT sets out the rules governing reservations, including that they must not be incompatible with the object and purpose of the treaty. For example, a state might reserve the right to exclude certain provisions of human rights treaty from its domestic law. Reservations allow states to modify their treaty commitments. They are only permitted if they are not incompatible with the object and purpose of the treaty. Article 19 VCLT states that states may make reservation unless A, the reservation is prohibited by the treaty, B, the treaty provides only for specified reservations, or C, the reservation is incompatible with the object and purpose of the treaty. The legal validity of reservation is determined by the state parties. There is a debate between the permissibility and opposability schools of thought on this issue. The permissibility school argues that a reservation is valid if it is compatible with the object and purpose of the treaty. The opposability school argues that a reservation is only valid if it is accepted by all other states parties. In the context of human rights treaties, the UN Human Rights Committee has asserted its rights to decide whether a given reservation is compatible with the object and purpose of the treaty. This position has been criticized by some states who argue that it undermines the sovereignty of states. The ICJ first considered the legal validity of reservations in the Reservations Case 1951. Under Article 20 VCLT, it details the extent of reservations, while Article 21 explains their effect. The key case, it was Anglo-French Continental Shelf case in 1977, where the ICJ held that a reservation by France to the Continental Shelf Conventions 1958 meant that Article 6 of that conventions could not be used to resolve disputes in the English Channel. The VCLT provides guidance on treaty interpretations, stating that a treaty should be interpreted in good faith in accordance with the ordinary meaning of its terms. In their context and in light of the treaty's object and purpose, this means that the interpretation of a treaty should be based on the text of the treaty, as well as the context in which it was negotiated and the purpose it was intended to serve. Treaties should be interpreted in good faith, considering the ordinary meaning, context, and the object and purpose. Article 31 VCLT interpretations provides that a treaty shall be interpreted in good faith in accordance with the ordinary meaning to be given to the terms of the treaty in their context and in the light of its object and purpose. Article 31 there are three approaches to treaty interpretations based on Article 31. Textual, which is objective, intentions of the parties, which is subjective, object and purpose, which is purposive. The ICJ has expressed a preference for the textual approach, but also recognizes the importance of considering subsequent agreements, subsequent practice, and relevant rules of international law. For example, in the case of Nicaragua versus United States 1986, the ICJ considered the subsequent practice of the parties in interpreting the meaning of the treaty. Article 31, Clause 3 VCLT allows courts to consider subsequent agreements, practices, and relevant rules of international law when interpreting treaties. This was demonstrated in the Namibia Advisory Opinion 1971, where the ICJ interpreted Article 27, Clause 3 of the United Nations Charter in light of subsequent practice. Article 32 VCLT permits courts to use supplementary materials, including preparatory works, to confirm or determine meaning when the interpretations under Article 31 is ambiguous, obscure, or leads to an absurd result. The key case was territorial dispute between Libya and Chad, 1994. The ICJ emphasized that interpretation must be based on the text of the treaty, promoting its effectiveness. The ICJ has shown preference for the textual approach in cases like the admissions case 1950 and the territorial dispute Libya versus Chad case 1994. The VCLT sets out the grounds for invalidating treaties, which can be divided into absolute grounds and relative grounds. Absolute grounds for invalidity are those that render a treaty void from the outset. These include coercions, which occurs when a state is forced to enter into a treaty under duress, and conflict with jus cogens, which refers to fundamental principles of international law that cannot be derogated from. Treaties can be invalidated on absolute or relative grounds. Absolute grounds, coercion, breach of jus cogens; relative grounds, error, fraud, corruptions, lack of authority. Under Article 53 VCLT, jus cogens, a treaty is void if, at the time of its conclusion, it conflicts with a preemptory norm of international law. Articles 46 until 53 sets out grounds for invalidating treaties, which can be absolute, rendering the treaty void, or relative, making the treaty voidable. Absolute grounds include coercion, Article 51, 52, and breach of jus cogens, Article 53. Relative grounds include error, Article 46, fraud, Article 49, and lack of authority, Article 46. Relative grounds for invalidity are those that allow states to challenge the validity of the treaty after it has been entered into. This include error, which occurs when a state makes a mistake about the content of the treaty, fraud, which occurs when a state is tricked into entering into a treaty, and lack of authority, which occurs when individual negotiating the treaty did not have the authority to do so. Article 46 until 53 set out grounds for invalidating the treaties. In Cameroon versus Nigeria 2002, the ICJ held that the head of state has the authority to conclude a treaty on behalf of their state, and such obligations cannot be avoided by reference to national law. Treaties can also be terminated through agreements, material breach, supervening impossibility of performance, or a fundamental change of circumstances. Termination by agreement occurs when the parties to a treaty agree to end it. Material breach occurs when a state violates the fundamental provisions of the treaty. Supervening impossibility of performance occurs when it becomes impossible for a state to perform its obligations under the treaty. A fundamental change of circumstances occurs when there is a significant change in the circumstances that existed when the treaty was entered into, making it impossible for the state to continue to perform its obligations. Treaties can be terminated by agreement, material breach, supervening possibility of performance, and etc. Article 60 of VCLT, the material breach. A material breach is the repudiations of the treaty not sanctioned by the VCLT or violations of a provisions essential to the accomplishment of the treaty's object or purpose. Material breach is defined in Article 63 VCLT as a repudiations of the treaty not sanctioned by the VCLT, and B, the violations of the provisions essentials to the accomplishment of the object or purpose of the treaty. In the case of Gabčíkovo-Nagymaros case 1997, the ICJ held that Hungary could not invoke a material breach to terminate a treaty as no breach had occurred at that time. In this case, the ICJ illustrates the application of these principles. The ICJ rules because Hungary couldn't invoke a material breach in May 1992 because no breach has committed at that time, but Czechoslovakia was in material breach when it diverted the river's waters in October 1992. The relationship between treaty breaches and state responsibility is an important consideration. The defenses to state responsibility can enable a state that has breached a treaty obligations to avoid liability for its actions. For example, a state might argue that it was acting in self-defense or that it was forced to breach the treaty due to a situation of necessity. State responsibility, the breaches of treaties can lead to state responsibility, with defenses such as necessity and force majeure potentially excluding wrongfulness. In Rainbow Warrior Case 1987, the panel observed that the legal consequences of a breach of a treaty belong to the customary law of state responsibility. The relationship between treaty breaches and state responsibility was explored in the Rainbow Warrior Case 1987 and further elaborated in the Gabčíkovo-Nagymaros case. These cases establish that defenses to state responsibility could potentially allow a state that had breached a treaty obligations to avoid liability for its actions. Treaties are the most significant method of creating international law today. Understanding the legal rules governing their formations, operations, and terminations is therefore crucial. While there are parallels between treaty law and contract law, particularly regarding consent, it's important to recognize the fundamental differences. Treaties are legally binding agreements that commit parties to follow specific courses of conduct to rights and/or obligations. The Vienna Conventions on the Law of Treaties 1969 defines a treaty as an international agreement concluded between states in written form and governed by international law.